Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, law offices across and associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of vandalism while being under the influence of drugs. Criminal attorney, criminal attorneys, criminal lawyer, criminal lawyers, DUI attorney, DUI attorneys, DUI lawyer. Let's see here. My 17-year-old son is accused of vandalism while driving high and driving my car and without a license. Well, we have a combination of issues here. Number one, this is a 17-year-old, which means his case is not going to go to adult court. It's going to go to juvenile court. That's good because in the juvenile detention or in the juvenile system, it's not so much about punishment, it's more about rehabilitation. So that's already, off the bat, that's good for your son, although he shouldn't be doing this. Now let's talk about the vandalism. Vandalism, that is a violation of Penal Code Section 594. That can be filed as a misdemeanor or it can be filed as a felony. It's a felony when the damage you caused or your son caused is $950 or more. If it's under $950, it's going to be a misdemeanor. Misdemeanor carries up to 1 year, felony carries up to 3 years for vandalism. Like I said, it would be in juvenile detention, not in county jail. Now, it says right here that he was under the influence. He was high. Well, they could also file a charge for a violation of Health and Safety Code 11550, which is being under the influence of a controlled substance. Now, here's the deal. Voluntary intoxication, I've said this many times before, voluntary intoxication is not a defense. It is not a defense. You cannot say, oh, well, I did this bad thing because I was high. No, if you got yourself drunk or high on your own, not because you got kidnapped and somebody shoved a needle in you, if you did this on your own, you will be responsible for the actions that you commit while under the influence. Now, being under the influence of the controlled substance would be basis for you to get, for your punishment to get minimized. It is a mitigating factor, but it's not a defense of the crime. Now, it says right here, driving my car, I'm assuming, yeah, the father's car, and without a license. Well, first of all, driving without a license, that is a misdemeanor. A lot of people get confused when they hear that. They think, oh, it's just a traffic ticket. No, well, at the police officer's discretion, yeah, but it is, it can be a misdemeanor under Vehicle Code Section 12500 here in the state of California, which, believe it or not, carries up to 6 months in the county jail. Don't be driving a car without a license. Now, it says right here that the son drove the father's car. Here's my question. Did he have dad's permission or not? Because if he took the car without the father's permission, there's another charge. They can hit him with a violation of Vehicle Code Section 10851, which is driving a vehicle without the owner's permission. That can be filed as a misdemeanor or it can be filed as a felony. Generally speaking, if it's a father's car, that's gonna be a misdemeanor under Vehicle Code Section 10851. It's not like he stole the car necessarily. That carries up to 1 year in county jail, but it's very, very rare that somebody would actually get that. However, if the dad gave permission to the son to drive a car, knowing full well that the son did not have a license, that could be problems for the dad. All right, that would be a violation of a Vehicle Code Section 14604, which is letting somebody without a license drive your car. It's a misdemeanor, which carries up to 6 months in the county jail. So, fortunately for your son, this case is going to go to juvenile court, and there's a very, very high probability that he's not actually going to have to do any custody time. Provided that you agree to supervise him, he could be released on an electronic home monitor. Home is essentially going to be his jail, and more likely it's just going to be a combination of fines that you're going to have to pay and a pile of community service that your son is going to have to serve. Regardless, the best thing is that once he's off probation, he can get his arrest record sealed, so that in the future this doesn't affect him at all. That's the best thing about the fact that it's a juvenile case and not an adult case. If it was an adult case, it'd be far worse. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, call us now for a free consultation at 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who got accused of some battery. Criminal attorney, criminal attorneys, criminal lawyer, criminal lawyers, DUI attorney, DUI attorneys, DUI lawyer, DUI lawyers.